This program is brought to you by the Practicing Law Institute, a nonprofit learning organization dedicated to keeping attorneys, professionals, and accountants at the forefront of knowledge and expertise.
Hello and welcome to the Insecurities Podcast, keeping it fresh and staying wonky on the latest securities, regulatory, and enforcement developments, with a practitioner's perspective on the stories you should be following. As always, I'm Chris Eckimoff, and I'm here, Kurt, with my co-host, Kurt Wolf.
Yeah, it's good to see you again. We are once again recording in person at the SEC's headquarters in Washington, D.C. I don't know why they keep letting us in the building. I can say that these visits are, I'm going to say, more fun, maybe friendlier than the circumstances in which I usually am coming.
That practitioner's perspective is different, right?
Exactly. I didn't get escorted to the basement into one of the testimony rooms today. We're actually upstairs on the 10th floor with Commissioner Uyeda. We're going to talk a lot today about rulemaking, sort of the commissioner's view of what the commission should be doing with respect to rulemaking, and what maybe the current commission is actually doing from his perspective. I think there's maybe a little bit of a delta there. But before we get into that, Chris, why don't you tell us a little bit about the commissioner?
Be happy to. Mark T. Uyeda was sworn into office as an SEC commissioner on June 30th of 2022. But he was not a newcomer to the building. Commissioner Uyeda has served on the staff of the SEC since 2006, including as senior advisor to Chairman Jay Clayton, senior advisor to acting chairman Michael Piwowar, counsel to Commissioner Paul Atkins, and various staff positions in the Division of Investment Management. Most recently served on detail from the SEC to the Senate Banking Committee, where he served as securities counsel to the committee's minority staff. Prior to joining the SEC, Commissioner Uyeda served as chief advisor to the California Corporations Commissioner, the state securities regulator. He also worked at the law firms K&L Gates and O'Melveny and Myers. Commissioner, thanks for joining us on Insecurities.
Well, thanks for inviting me to be here. As your audience is probably well familiar with, the remarks I give today are my individual views as a commissioner and do not necessarily reflect the views of the full commission or my fellow commissioners.
Understood.
We got disclaimer on the bingo card out of the way here early for the episode. Thank you, Commissioner. So, Commissioner, before we get into SEC rulemaking, let's talk for a moment about the U.S. capital markets generally. There have been many market innovations and enhancement in recent years, which include things like the proliferation of investment apps and commission-free trading. Kurt, we've talked a lot about on past episodes of the podcast. But, Commissioner, what's your view of the marketplace right now, and maybe specifically to retail investors?
Well, that's a really important question. Although I do want to address something that Kurt said earlier. He said, I'm not a newcomer to this building. The only time he's been here is in our testimony rooms. Believe it or not, it was only 2 weeks ago was the first time I ever stepped in and saw what our testimony rooms look like on the second floor. And that
Similar
was
review that Kurt gave?
Yeah. Well, right now, especially with a lot of things not being done in person, we have all these rooms there. I'd passed by it many times, and I was taking a staff member there and said, I'm not quite sure what our testimony rooms look like. Let's go in here. I started in this building back in 2006. I had not seen it. So, all right, I now know what you're talking about when you say into these dark rooms.
It's not as bad as I made it out. They're nicer than some other agency's testimony rooms. So I don't want to give a false impression here.
Okay. Excellent. So, Commissioner, back to talking about the retail investors and how the market is from their view today.
Well, I think it's really never been the better time to be a retail investor. I mean, we think about the developments that have occurred in the past 20 years alone, which doesn't seem like it was that long ago, that it was 2003, but even before that. I remember, to date myself as a kid growing up, you had the commercials from E.F. Hutton. When E.F. Hutton talks, people listen. And You'd actually have to call a broker. You'd actually have to go physically to a broker-dealer. Now, what do we have? We have commissions that are very low, or in some cases, not an express commission. We have spreads that are tighter than ever. We have widespread access through mobile apps and the internet. One of the things that we've always thought were concerning, especially when we think about the ability of persons and households to accumulate wealth in this country, that in a bricks and mortar society, it's somewhat akin to the concerns that we had in the Community Reinvestment Act where physical bank branches were present. We have the same thing with broker-dealers. But now, by and large, as long as you've got access to the mobile phone network or the internet, you can access that. So another thing is either no or very, very low minimum balances. If you can imagine having a minimum balance of $5,000 for somebody who's just getting started, that can be a big hurdle or a deterrence to getting into saving and investing. It's all the more important today when we don't see the traditional defined benefit plan available. So between your 401k, between your IRA, between your other non-retirement savings accounts, you're going to have to prepare for your future. And I think it's really interesting to me, the reaction when I do talk to younger investors and you start talking about the time value of money and the return that you get if you invest early and how much your retirement outcomes can be different if you start putting away a little bit of money now when they're out of school in their 20s, and they can be modest amounts, and then as hopefully their income increases over time, they're able to put that aside and put more and more amounts aside, and then just it's a huge difference if you start doing that in your 20s than if you start doing that in your late 40s.
And you spoke a little bit about how the ease of investing is now. Kurt and I were joking a bit down in the visitor center about some of the older photographs of commissions past and how different things may have been back then. E.F. Hutton may be predating a lot of that as well. So when things are as good as they are for retail investors today, how does that impact the commission and the mission of what's going on here in the building?
The way I look at it, the securities laws are incredibly flexible, and I like to think that was so we can react to these changes. And it's one that we need to understand the technological changes and how that's affecting things. One thing that I first saw on one of my projects, came in here in 2006 with Commissioner Atkins, and after that went to go join our Division of Investment Management, and we were working on the summer prospectus. And a lot of it was, how should we think about prospectus delivery in the context of an electronic delivery world? Yeah. And again, the assumption was they would be on people's computer screens as opposed to mobile phones or iPads or things like that. So we, I think, have a statutory framework which allows us that. And I think that's one of the important things that if we're to remain an effective regulator, we have to think about, well, how is this information reaching individuals? How do they think about these things?
Yeah, it's a good point, and I think sort of takes us in the direction we want to go, which is thinking about rulemaking, right? So how, as things change, whether that's through technology or otherwise, does the SEC adapt, whether that's through new rules or through amending existing rules? It's something we talk a lot about here on the Insecurities podcast just in the last, year or 18 months, Chris. We've talked quite a bit about the Reg Flex agenda. It's something we spoke with Nick Morgan about a few episodes ago. He was kind of talking about the traditional notice and comment rulemaking process and where maybe things look a little bit differently from his seat, at least, and how people like his organization, ICANN, can participate in the rulemaking process through comment letters. But sometimes that isn't always on the table. I think his bigger point, and the one we want to put to you, is that it feels like things from a rulemaking perspective are maybe a little bit different than they used to be. As we noted, you've been in the building for a while. You served for Chair Clayton, Acting Chair Pivovar, and Commissioner Atkins. So plenty of time here on the 10th floor, even if until recently you hadn't been all the way downstairs.
That's right.
But the question is, thinking across that experience, have you observed, since you've been a commissioner, any differences or deviations perhaps in rulemaking practice here at the commission?
Well, certainly I would differentiate between our Reg Flex agenda and the rulemaking practice. I've always felt our Reg Flex agenda ought to be accompanied by a forward-looking statement disclaimer and with lots of risk factors on there. Because even when you put out the agenda, that we could still drop something in there that's not at all as a proposal on the agenda. The dates, there are different approaches on that, but right now the current practice is more or less you either select a month that's April or October. And there are many rules that we have on the current public agenda that, for instance, were said October, and we were doing them in May and June. And also, there's a huge lag time. Between when we internally develop that and by the time it's finally made public via the Federal Register. But that's, like I said, a separate question, I think, than how we approach rulemaking. And I think if you can almost compare and contrast what happened under the prior chairman and Chair Gensler, not suggesting there's any right way to do this. Each chairman has a lot of authority, and a reorganization plan tend to set the agenda how he or she sees fit. And sometimes the chairman does not actually have that much discretion because when Chair Shapiro came in, we had Dodd-Frank, and there were lots and lots of mandated ones that he had to do. And Chair White was similarly things that had not yet been completed on that agenda. It was left to her to finish. I was detailed to Treasury in 2017 and 2018, and one of the things was there was a desire to be thoughtful. Let's think of all the pieces fit together in Treasury's view with the capital markets, the banking sector, the insurance sector, asset management, and then try and at least put out a thought piece. And so I helped write 3 of 4 reports about that. And it was really meant to say, here's one, what we think the overarching goal of financial services regulation ought to be, and 2, here are a number of ideas and recommendations as to how that might be achieved. But then leave it up to the independent regulatory agencies, whether they're the SEC, the CFTC, Federal Reserve, the OCC, and so on, to then exercise their own independent rulemaking authority to adopt, modify, not adopt, but it would allow that feedback. Now, one of the downsides with that is if you spend a couple of years trying to develop that, I mean, we got ours out at Treasury a year, but then we have to do the rulemaking process to draft a proposing release and then to take public comment and then to adopt and then to implement. All of that takes usually over the course of years, not months. I mean, and so here what Chair Gensler has done is basically rolled out a lot of things very, very quickly. Because if you don't have the proposals out, it really makes it difficult to adopt things at final. And if you look at the past, going back to Chair Cox and Chairman Levitt, when an administration ends, they will have a new chairman, and so one never knows what might happen. So there is a bit of that. Even though we are an independent federal agency, there is a bit of that timing that affects how one thinks about what they want to accomplish and the time to do that. So we've had all these things. Now, I think one of the downsides is of flooding the zone, so to speak, is it starts to become a real challenge as to understand how all of these things work together. We're really worried about, for instance, in the trading and market space, about both fixed income and equity market and treasury market structure. I mean, we're doing some things there because part of our mission, fair, orderly, and efficient markets. At the same time, we're doing some things, for instance, with liquidity on funds. We have a separate proposal on that. How will those things play off of each other? And especially when, I think the real challenge for us as an agency is we have different bureaucratic units. I mean, that's a necessity. There's a reason for why we have trading markets and IM and CorpFin, but how do they all interact? If we start placing, for instance, additional restrictions on mutual funds and ETFs, because, or I should say primary mutual funds, that's what the liquidity proposals aimed at, their ability, for instance, to hold certain securities with liquidity characteristics, that might restrict their ability to actually enter into the market when there are volatile times. I mean, if you think of a mutual fund, let's say a fixed income portfolio manager, they want to buy when prices are attractive. In times of market volatility, and we see, for instance, sudden declines in prices, rise in yields, portfolio managers say, I want to buy. And that's exactly the type of counter-cyclical activity that we want for the markets, because that then returns it back to an equilibrium. And if, from a regulatory standpoint, would our proposed liquidity proposal, would that somehow create unnecessary frictions? And those are the types of things you want to think about. Have we got it right? You look at the public comments, and you work with our economists, and you try and figure that out. But if we're doing things really fast and teams aren't able to make those connections or make them as well as I think we ought to do, given our important role as the capital markets regulator, that's what I find, I think, the part that I get most concerned about. And because we have so many wide-ranging, very, very broad proposals right now, I really worry, am I seeing all the connections I should be seeing? Is the commission thinking about all those interconnections that we ought to? And that's my my big fear with the current rulemaking agenda is we haven't done that, and we're going to find ourselves saying, well, we didn't intend this potential bad outcome, but part of it might be that might not have been our intent, but did we approach the rulemaking in a prudent manner to understand the possible interactions where we can make an informed choice?
So, Commissioner, I'm picking up on a few maybe themes or threads from sort of your response to how things might be different from what you've experienced in the past. I hear you talking about the volume or the sheer number of rules that are popping up on the agenda, the speed with which the Commission is trying to sort of nudge them along or push them through, and maybe the overlap or the interconnectedness of those rules, and whether the Commission is thinking about that maybe in a holistic way. I mean, look, it seems to me like while those may be different to what you've seen in the past, it's sort of within the realm of things the Commission ought to be doing, at least to the extent they have authority to make rules or amend rules. But still, it seems like there's a lot going on. So my question is, from your perspective, where are the guardrails? How far does the SEC's rulemaking authority really stretch?
Well, that's a good question. If all we cite, for instance, if you look at the text, most of our rulemaking authority says we can do various things as long as the Commission finds it's in the public interest and for the protection of investors, which is even really a guardrail. And right. Of course, we've got the General Administrative Procedure Act provisions that say we have to have a rational basis and we cannot act in an arbitrary and capricious manner. Ultimately, our work product is subject to the review of the courts. Mm-hmm. And to a lesser extent, if Congress doesn't like what they do, like what we do, they always have the ability to pass legislation to change that. But we still need to make sure that we are acting in a manner where we have reasons for why we're acting. And I think I go back to when, I think it was then called RISC-Fin, and I can't remember the exact name, but now it's known as our Division of Economic Risk and Analysis. And they put out a memo about guidelines for economic analysis in rulemaking. First point, try to clearly identify the issue we're trying to resolve. Mm-hmm. And second, try to find what are the baseline for what we're going to compare it to. And then third is try to estimate, based the best we can on, but hopefully with data as to what the effect of the proposed change might be. And then fourth, compare that to what other alternatives we might have. And in securities regulation, it's oftentimes you do not have one single, this is the answer, this is the one, or to quote the Mandalorian, this is the way.
The way. Mm-hmm.
Usually you have trade-offs. And for instance, if we had a rule, one might cost $1 billion and we think it'll get us 98% of what we want to achieve. Another one may cost $100 million, but achieve 90%. So you have to think of the trade-off. Is the increase in marginal benefit worth the marginal cost on that? Now, I understand that the costs are never going to be perfect or exact, but you try to understand that the best you can, and then decide what those trade-offs are. Is there a way that we can accomplish more? How much does this matter? And sometimes, if you look only at the tree, or if you only look at maybe individual branches on that tree as your economic analysis doing a rule, we're going to miss the overall big picture on the forest. And sometimes you forget that these costs are ultimately being borne by market participants. Mm-hmm. We like to think that, 100% of this is borne by the Wall Street intermediaries. They're all taking their cut of transactions between investors and issuers. But a good chunk of those costs all get passed along to investors. So right. That's, in essence, almost like a hidden tax, so to speak, mm-hmm. on investing, raise the cost of capital. So I think it's everyone's goal is we want investor protection. We want fair, orderly, efficient markets. We want to facilitate capital formation. Regulation can help achieve all of those goals, but we need to do it in the most efficient manner as possible.
One of the things we talk about, Commissioner, with many of our other guests too, is those kind of guiding principles or foundational codes to live by, if you will, and how that reflects on their role as regulators or in whatever agency or area they serve. And You're kind of hinting at some of that with what we just discussed in terms of evaluating rules. And I like to harken back to, whenever we have a guest on, we always like to point them back to their own words. So we'd like to get back to something you spoke last year in 2022 at PLI's SEC Speaks conference and explained some of those factors and principles that guide you. You said, quote, analyzing regulations using a 2x2 matrix. One axis is labeled whether a regulation is effective or ineffective. The other axis is labeled whether a regulation is costly or not costly, end quote. And that goal there is to kind of be up and to the right? Maximally effective or at least not as burdensome or costly as you just described. You talked a little bit about your position on where rules should fall, but how do you feel the commission as a whole is currently considering or developing or maybe even scoring on that scale?
Yeah. I worry because a lot of our rulemaking right now, we tend to fall back on what we call qualitative factors. Say, well, we can't figure out quantitatively what the impact is, but qualitatively, they'll use a phrase which I have criticized, is the commission believes. Okay, well, how did we reach this belief? And I think we have an obligation to articulate exactly why we've reached this belief. And a lot of times, I think the belief is really an assumption. We assume that this is going to work in this particular way. But again, how did we reach that conclusion? How well do we understand what investor preferences really are? One thing, when I go out to talk to retail investors, I was out recently at an event, an investors forum up in Wisconsin, and a lot of the retail investors said, we're not unintelligent people. We're not ill-informed. But I've got a master's degree, I'm a college graduate, but I'm just not interested in personal finance. That's why I'm going to hire someone to do that. And the vast majority, at least I think, on some of the surveys, say Americans are not that interested in personal finance. But in some ways, it's no different. Plumbing and electrical systems are important in our lives, but that doesn't mean I should know how to be the plumber or the electrician.
I just want to make it clear that my wife should listen to that statement, that we should not be the plumbers and the electricians. But please, Commissioner.
And that's why they do hire financial advisors, whether they are a broker or an investment advisor or sometimes both or others. And so we need to think exactly how the markets are reaching retail investors. A lot of I mentioned the flexibility of the securities laws. I think they were really written originally at a time where there was a lot more direct investing. People made their choices. Now we have a lot that does flow through an advisor or it goes through a diversified financial product, whether it's a mutual fund or an ETF or through something in a 401k plan and a collective investment trust. So we need to make sure that what we're doing informs all of those different avenues and not just only assume that it's a direct to retail investor channel. I think a lot of people who work at the SEC, we like it. One reason we work here is we like securities. We're almost passionate about this. But then you realize that's not how a lot of Americans think about being passionate about. Some are, which is great.
Our listeners will be stunned by this news.
Not everybody loves this stuff. Get out of here. No, that's and I think as an accountant, right, I'm always looking for the quantitative side of everything, right? I understand qualitative. Kurt, that's more maybe your alley than mine.
Definitely more qualitative.
Maybe higher quality too, but we'll leave that for another one. But I want to talk about kind of that cost-benefit analysis that we've revisited earlier. Earlier this year, in remarks to the Investment Company Institute, you warned of the, quote, perils of regulation by theory and hypothesis, end quote, which I believe kind of that the commission believes statement really leads into. You actually listed more than 15 proposed and final rules that are affecting asset managers and remarked that, quote, in the commission's rush to rulemaking, there is no question that significant compliance challenges and costs will result, end quote. So how can the commission do a little bit better job at that cost-benefit analysis or consider some of those quantitative factors?
Yeah. Well, for starters, I think especially as we are proposing new rules, and even now when we're adopting them, we need to think about what are going to be the cumulative impacts of all the other things that we are doing. Because the big fear is you're going to try and, again, put it into these really small, very narrow pieces, but not be able to analyze everything as a whole.
Right.
As a whole. The benefits, for instance, when I think of the 4 proposals we put forth on equity market structure last December, one of the ones that we've got a lot of commentary on is the order competition model. Now, the benefits of the order competition model, that could change depending on what we do, for instance, on the Rule 605 reports, which have to do with broker executions.
Right.
It could change depending on what we do on the tick size, especially for tick-constrained stocks. And similarly, best execution proposal, that could change depending on what we do on those other 2 as well. We haven't looked at, for instance, the Rule 605 disclosures in 20 years. If we gave more granular disclosure, as opposed to right now, it's somewhat aggregated on how the executions are, but not, for instance, telling you how your trade got executed. Would that allow investors to have more information, in essence, allow competitive forces? Broker X gets continually better executions than Broker Y, and then allow markets to say, well, if Broker X gets better executions, I'm going to use Broker X then. And then that would, market forces, Broker Y would say, well, hey, if we're losing all this business, we better get better executions. That's, in my mind, as a markets regulator, what I want to see. I want to see competitive forces drive continual improvement. And again, that's what I think we've seen in the last 20 years with much tighter spreads. So given how one can be, I think, dramatically or potentially dramatically affected by some of what we may or may not do on the others, how should we be thinking about it? And our economic analysis ought to say this is the agency's view as to how we think about this. And it shouldn't be, which is, I think right now, I'll pretend those other proposals don't exist. We'll do it in a vacuum. If at the time we do a final rule, we've perhaps adopted one or more or pieces of one or more of these, then we'll consider that in the new baseline. But I think that's still not good enough to get public comment, because the public really deserves to know, hey, what's the SEC thinking? What is its view on what the problem is and how this solves the problem when we're doing multiple things? I think the other one I would point out is the cybersecurity. We've got between the Reg SP and the TM cyber and the IM cyber, the Reg SCI entities cyber, and then our recently adopted cybersecurity rule for corporate by the Division of Corporation Finance. How should they all think about all working together? Because you could have one entity that actually is subject to all of them.
Yeah, that's right. It's a scary Venn diagram if you don't know how to best do that. And that kind of flies, will be music to the ears of a recent guest we had, Kurt, or you recall all those weeks ago. Brian Corbett, who's the president and CEO of the Managed Funds Association, brought up that exact point of thinking about the cumulative effect of rules specific to the private fund space, obviously from his angle. So I don't think it's an easy problem to solve, but it's good to hear the commission's kind of thinking on that level and at least considering which way the wind may blow as these rules start to move into a final posture.
Well, I'll remind you again of my disclaimer. That is how I, as an individual commissioner, not necessarily the full commission.
Yes. Thank you.
It's interesting to me, though. I hadn't thought about it quite like this before, the way you've articulated it in terms of the interconnectedness, because as an outside observer, you will sometimes see statements that say, like, today we have released a suite of rulemaking proposals that are designed to X, or today we adopted 4 new rules or amendments that are designed, right? Like, this is what happened. Chris, this is my moment. This is what happened with Reg BI a couple of years ago, right? We got a new Reg BI, we got investment advisor guidance, we got another piece of guidance, and like these, by their powers combined, everybody should know what's going on now, right? I guess I would have thought that there was more analysis happening on the interconnectedness of those rules, particularly to the extent that you're sort of rolling them all out together. But I gather there's maybe some room for improvement there in your view.
Yeah, well, I'd certainly say there is no public disclosure in the proposal releases of our analysis of the interconnectedness of these proposals.
Okay. Well, you've mentioned a couple examples of where maybe we could think a little bit more critically about the interconnectedness of some of the rules. I don't want to get too deep in the weeds with respect to any particular rule or subject matter, but there is an area we haven't touched on yet that because we're talking about the SEC at all, we have to, and that would be crypto, of course. I think you would agree with me that the commission has authority to create a rule, amend a rule, offer some guidance as to what a security is. But I think many have commented publicly, I won't share my view, that hasn't really happened, right? I know that some of the other members of the commission will say, well, look at the Dow report or look at some of the enforcement actions, and there have been quite a few at this point, and there's all the guidance you need to figure out whether or how you are operating in a regulated space. Commissioner, where are we with respect to crypto regulation?
Well, you raise a great point here about our authority to define terms and definitions, and I think we certainly do under the statutes. Earlier, just a few minutes ago, you talked about the fiduciary interpretation, and I'd like to compare and contrast what we did with respect to fiduciary versus crypto. And the reason why I say this, both of them are similar in that they have as their touch point Supreme Court precedents. For fiduciary duty, it is SEC versus Capital Gains Research Bureau. And in the crypto space, it's of course investment contract, SEC versus WJ Howie. So in the fiduciary, it was, the Supreme Court says there's this fiduciary duty. It's kind of worked out in various places. There are court case judicial decisions on that. But it's enough of a mishmash of different sources where the commission said, you know what, let's go out and put out an interpretation using, in essence, our authority to issue guidance on that. And the important part is now we have a fiduciary duty, because like I said, it's by case law. So what the First Circuit might have held is different than what the Eighth Circuit has held. So we can actually create a national standard. This is how the SEC views, and we will apply it throughout the entire country, or for all those who are registered with us, and have those duties. So let's contrast that to an investment contract under Howie. Well, we know that just historically, the investment contract, there are splits within the circuits. You could say, yes, we're going to apply the Supreme Court's decision, but guess what? The precedents in each of the circuits can differ. Well known, for instance, on whether you need pre or post offering efforts of others to satisfy Howie. The DC Circuit has one opinion, and there's a contrasting view in the 11th Circuit. So the whole mutual benefits versus life partners distinction. We could have done something like that with respect to crypto. This is how we think about the investment contract. And it would have the benefit of someone not having to think about circuit by circuit splits and precedent on that. We could have put it out for public comment. We could have, and to the extent that whatever we did at the end, someone really says you're wrong. Again, we're subject to judicial review of our decisions on that. And we could have gotten a decision on that. Or if Congress didn't like what they did, they could pass legislation on that to change that. But it would have been, here's how we think about it, here's how we apply the various components of the investment contract test under Howie. And this is how we would think about it, not just in one circuit, but throughout the whole country. So we haven't done that. Instead, we have done things through largely litigation. So far, I think we've had primarily settlements, but there are some that are now contested, and I understand these things take time to work their way through the courts. That's also another issue. Even when you get a decision of a district court, that does not have precedential value. It might have persuasive value as authority, but if it's a single district court decision, it's not precedent until it gets to the circuit court. So if we really believe that there are significant concerns in this area, why would you wait for potential years to do this when we could do it? Again, here's how we view the world. Here's what we think is in and out. My biggest concern when with enforcement is oftentimes you interpret the law to achieve an outcome in a particular case. There's less thought about programmatically, what does this mean? Because I think those who are involved in litigation, they're really thinking about the matter at hand, whereas, yes, I do have to sign off on our enforcement actions as a commissioner or vote on them, but I also need to think about the broader policy issues. I need to think about what the law is. I need to think about how we apply the investment contract test. And for instance, what are the limiting principles? Because market participants should be able to understand where the line is. This is a security, therefore it needs to be registered. This is not a security, it doesn't need to be registered. Recently we had a case, it wasn't our case, but we were asked by the Second Circuit to provide our views as a commission on whether or not syndicated loans were securities on that. Now, there, the issue specifically was the Reeves test, which is not the investment contract but there, again, market participants ought to know if I'm engaged in syndicated loans, do I need to register this with the SEC? Do I need to find an exemption? What about transaction-based compensation? Do you need to run this through a broker? Is it in or is it out? That's a really important issue. And ultimately, we told the court we could not offer an opinion, even though we asked for 3 separate extensions from the court in order to file some sort of response. I don't know if it would have been technically an amicus brief or some other response. But those are the types of things where I think market participants need to know whether the jurisdiction of the securities laws applies or it doesn't, because it's just so fundamental about how everything else flows after that. And that's something that I wish, and it's still not too late for us, but we ought to be providing that as a regulator as opposed to the bit more piecemeal approach through enforcement actions.
Yeah, I mean, it sounds like there are a few, I don't want to pick on crypto in particular, but a few areas where maybe the commission could speak and hasn't done so. And sometimes even just giving guidance is the way to go. I mean, another example that comes to mind for me relates to the whistleblower rules. A number of years ago, the commission issued guidance about what was sort of in and what was out with respect to the retaliation or the anti-retaliation provisions, right? And that ended up, somebody challenged that interpretation. The digital realty, I think, was the case, right? So we got, in relatively short order, the commission's view and the court's view, which didn't necessarily align with the commission's view, but then we knew, right? So there's a way to do this. But it's always interesting to me, outside of those examples, how frequently enforcement actions are held up as some kind of guidance or quasi-guidance. Again, that happens a lot in crypto. The more that happens, I think the more we hear complaints about regulation by enforcement. Even a couple of years ago here on the podcast, we've joked about this before, but it was almost taboo. We didn't really want to talk about regulation by enforcement because nobody was sure if that was actually happening or not. People had different views. Now I feel like a lot of people think that's what's happening. Again, particularly with respect to crypto, but not only crypto. There was a recent enforcement action. You and Commissioner Hester Peirce released a statement, a dissent really, regarding an SEC enforcement action against DST Asset Manager Solutions. No questions about any particular case. We don't want you to comment on that. But I thought that your observations, or your and Commissioner Peirce's observations, were interesting. And you said, quote, "The Commission once again uses an enforcement action as a substitute for notice and comment rulemaking. The Commission may, consistent with the Administrative Procedure Act, engage in rulemaking to supplement or amend existing requirements. But the Commission is a victim of its own misguided overambition. What is a regulator to do when it cannot fit one more rulemaking on the calendar? The answer appears to be send enforcement to do the rulemaking." I mean, I love it. It's very well written, very, very pointed. But I guess sort of an open-ended question for you, bearing in mind those comments. What are the real dangers of regulation by enforcement?
So the real dangers, I think, of regulation and enforcement are that without exposure to the public of how we think the solutions are, you can't get their feedback. Because when you're doing a settlement, it's the SEC enforcement staff in the room, and it's the defendant and the defendant's counsel. Those are the only two parties that matter. You can't have the rest of the public saying, well, actually, maybe programmatically this is the wrong thing to do, especially when we think about undertakings. We have statutorily authorized penalties and other remedies that we can seek. For instance, there are various collateral bars that can be imposed depending on what happens on the underlying action. But undertakings, and this is something that I saw and I know when I was with previous commissioners on serving as their counsels, was, well, we can't get a civil penalty here, so they'll undertake to make a payment to the SEC of X amount of dollars. And that seemed, well, that appears to be a bit of an end around on the statute. In fact, if we can just require undertakings on everything, then we really need no statutory authorization for any sort of remedy,
Right.
or penalty. We can just do it all through undertakings. Now, here we're talking about, are we doing things to achieve through rulemaking? And the particular issue was certain disclosures that were going to have to be made by or through persons who are not at all a party to this enforcement action. And I thought that was very troubling, that here we are, persons are being affected. And again, they didn't have the opportunity to say, well, wait a minute, this doesn't really apply to me, or I've got these concerns on this, or how much will this cost me to do, or more likely, since all of the regulated entities are subject to record-keeping requirements, policies and procedures, being able to demonstrate that you've implemented and complied with those policies and procedures, there's a whole line of things that then have to go into effect to carry out those obligations. And again, none of that gets even brought into consideration in the context of an enforcement settlement.
Right. I agree.
Shockingly,
No, I mean,
Kurt
I've
agrees.
had a few where sometimes as defense counsel we'll actually make those arguments. We'll say, listen, sort of programmatically, let's think about how this might play out, or how others may have to implement or think about this. And I don't know, sometimes it's well received, sometimes it isn't.
Well, you say that, but you have to remember your obligations as defense counsel. It's to your client. It's not. You can't subordinate the interests of your client to the public interest. Mm-hmm. And many times you might not agree with it, but if your client says, I can live with that, and I want this to be over, I want it resolved so I can move on with my business, you need to think about that. And again, that's why, again, my concern is the public interest isn't represented in that room.
Right.
And nor would I say, given the obligations one has under our codes of ethics as attorney, is it appropriate for someone to be representing that?
Yeah.
Commissioner, I know we've talked about a few things that really come down to what you just described in terms of their impact to the public interest, right? What impacts do we have from a regulation by enforcement, from the rulemaking process? And if I could repeat back what we're hearing from you, really an aggressive rulemaking agenda. What types of things should the average investor be looking out for? What type of risks are out there for them with what we're dealing with across all three of those fronts? Not just from that extension of, say, that individual case now impacting others in a similar situation with regulation by enforcement, but the market at large.
Well, there are a lot of different participants in the markets, and I think they affect them differently. I principally think of the retail investor. Mm-hmm. Again, the retail investor is going to be affected. And what does it mean for them in terms of how they access financial products and services? And will it mean, for instance, additional costs? What will those costs look like? Will they mean services that they might like, but they can't have? Will that be a possibility of what happens if we go forward with our rulemaking? Will there be a decrease in choice? With regulation, and especially the compliance burdens, there is an economies of scale component to that. And so am I concerned about the potential anti-competitive effects of a very, very high regulatory burden? Yes, I am. And in fact, Congress tells us we should be concerned about that. Right? That's one of the provisions that was already in the Exchange Act, and then it made clear it applies to the other acts by NISMIA when they had the efficiency, competition, and capital formation consideration requirement. So those are the things, and they can be difficult to tease out sometimes, but I think retail investors, yes, there is always risk that a new development or a new method or new innovation might be to their detriment. But there's also tremendous opportunity on that. And for instance, going back, Chair Gensler's given some speeches on this, and perhaps some of the other commissioners as well, about digital engagement and certainly elsewhere outside, I'm talking about nudges on things. What I would not want is the nudge to be don't invest at all. And I think what we've had is tremendous more ability to access those. And again, there are lots of opportunities there, and our job, I think, is to try and mitigate or reduce to the extent the downside risks of that. So think of the bad brokers out there and others, but there are many others out there. The reason for why their services are in demand is because investors do want the ability to have economic gains, to diversify their assets. One of the things we talked before joining the SEC, I was with the California Department of Corporations. They were the state securities regulator, but they also regulated the non-bank lending in California. And so in terms of thinking about how certain credit was being extended, and those were in the early 2000s were, and unfortunately the laws were relatively weak in terms of, for instance, the ability of a loan borrower, as long as you accurately represent the terms of the loan. So very easy credit. And one of the things of, well, why are folks taking up so much credit? One of the things we got back through our investor education folks is people just don't trust the stock market. Because keep in mind, this is after Enron, Health South, WorldCom. We had the New York Attorney General out there, and it was all of Wall Street's crooked. And so when it was kind of interesting, how are people getting like 3 different homes as investment properties on no money down, no doc loans on this? And well, one, there was basically a demand for these for, we now know how this turned out, but but these asset-backed securities were vacuuming up all sorts of secured real estate. But there was one, I remember remembering in that role, a constant theme was, well, that's because this is real. I can touch this house. I can feel this property. I don't know about these stocks. There's something that's, they're on my brokerage statement one day and then they're gone the next. So this is why they're going to go into those sorts of, that was where they're going to put their wealth. Hopefully I think we as investors, regulators, market participants, we've learned from that, and kind of goes back to the old adage, don't put all your eggs in one basket.
Right.
And again, through these new developments, we've made the ability to have a diversified portfolio much more accessible than ever before. And so we want to make sure that we constantly think about those, what can be done to create a better investing environment for the average American household.
I think it's a great note to end on what can be done to make things better for retail investors in the average American household. Commissioner, I've really enjoyed the conversation. Thank you so much for taking some time to chat with us here on the Insecurities Podcast.
Well, thank you.
Thank you. Thanks for joining us for this episode of the Insecurities Podcast, and a special thanks to our guest, SEC Commissioner Mark Uyeda. As always, we want to hear from you regarding your thoughts, comments, and topics for discussion on future episodes of Insecurities. Please use the hashtag InsecuritiesPod on X or LinkedIn to join the conversation. You can find me at EcomofCPA.
And I'm at Enforce_update.
Be sure to subscribe, rate, and review the Insecurities Podcast wherever you listen. Be well, everyone, and we'll see you next time.
Thanks for tuning in.
Thanks for listening to Insecurities, a podcast from PLI, the Practicing Law Institute. PLI is a nonprofit provider of authoritative professional services training and continuing education. In an increasingly complex business environment where intricate corporate structures reign, Insecurities can help you make sense of it all. A special thanks goes to the producer of Insecurities, Daniel Peinitz, as well as hosts Chris Ecomoff and Kurt Wolf. For more information about PLI's SEC Institute, or to view hundreds of hours of fresh and relevant on-demand programming covering changes within the securities sector, visit pli.edu/membership and sign up for a privileged membership. These recorded materials are designed for educational purposes only. This podcast does not constitute legal, audit, tax, consulting, business, financial, investment, or other professional advice, and it does not create an attorney-client relationship. Please consult a qualified professional advisor before taking any action based on the information herein. Furthermore, the views and opinions expressed in this podcast are solely those of the individual participants. These views are not the views of the hosts or their employers. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission from PLI.